good evening everybody in the room and in the virtual space out there. I'm Richard Cheney. I'm chairing tonight's talk by Richard Sergi and Ben Bradley. The topic is wrongful life and wrongful birth and the dichotomy they create. And I think the split of responsibilities has Richard speaking first about the difference between wrongful birth cases and wrongful life cases, and by reference to some quite well-known authority in the area, and then Ben is going to address on damages. I know from recently working with Richard on a joint advice about this topic that it is vexed, and I'm looking forward to finding out what I perhaps should have known before I weighed in on this paper with Richard a few weeks ago. I understand we've got a regime for questions to be asked by people out there in the ether, so if one is watching on Starleaf, there's a raised hand icon on the screen that allows you to make it known that you want to ask a question, and then you can be heard on the speaker here. And if you're watching on YouTube, I think you can engage the chat line, and your question will be conveyed by Shani, who's in the room at the back here. But we might hold all questions till the end and see if we can deal with them all in one place in the evening. So I'll call on Richard Sergi.
Repeat Richard's welcome to everyone. The first thing I'd like to do is to say that I'm not looking forward to questions, because I'm not sure I'll be able to provide some very sensible answers, but we'll come to that in due course. Tort law is fluid, and the boundaries of what injuries, losses and damages are compensable have changed over time. As the law have developed, there's been some controversies, and it's fair to say that the dichotomy between wrongful life and wrongful birth, and the birth of children in general, is one area of controversy. In this area of wrongful birth and wrongful life, it's important to start with some fairly basic fundamental propositions which are not, in my experience, readily understood, because the terminology is slightly confusing, so much so that it's probably best to start with wrongful birth and then move to wrongful life, even though the title is expressed in the reverse. Wrongful birth is a recognised cause of action. Wrongful life is not actionable. And it's important for us to, and I'll come to the reasons why in a little while. Wrongful birth, as you can see there, is essentially determined by Catnack and Melchior, and wrongful life, Harrington and Stevens, and then Waller and James. I'll address those in due course. But wrongful birth, first of all, is a claim brought by a parent in relation to the birth of a child, claiming that the birth could have been prevented but for the negligence of the defendant. The essence of the claim is said to be that, may move on. The essence of the claim is said to be that the parents have, as a consequence of the defendant's negligence, been denied the opportunity of determining the size and nature of their family, which has resulted from the birth of the additional child. And the measure of that loss is additional costs of caring for that child. And we'll come to the measure of the loss in due course, and Ben will address Part 11 of the Civil Liability Act and the common law in relation to that measure. Wrongful life, on the other hand, is not actionable. The claimant in wrongful life claims is not the parents but the child. In theory, at least, if it was available, and of course it's not, we'll come to reasons why in a little while, it could only be brought by the child, because that person, that plaintiff, is claiming that but for the defendant's negligence, the child would not have been born at all. The nub of such a claim is that the plaintiff's child's life with disability is so impoverished that they say they should not have been born at all. And that has presented some philosophical issues that we'll come to in a minute. Catnach and Melchior. Now, prior to Catnach and Melchior, which was determined in 2003 from memory, there were just a few decisions around various jurisdictions in Australia and lower courts dealing with claims for wrongful birth and the resulting damage thereof. The claims arose from various circumstances, but mostly for the loss of an opportunity to carry out a termination of pregnancy or failed sterilisation procedures that have then led to the wrongful birth that was alleged to the children. And in the usual way, the High Court was waiting for an appropriate vehicle to come along by which they could explore whether or not such a claim was actionable. And in 2003, the High Court heard Catnach and Melchior. Now, the facts in Catnach and Melchior may well be known to some of you, may not be known to others, or may have been forgotten by most of us. But they were that the parents of the child claimed that Dr. Catnach, who was an obstetrician, carried out a sterilisation procedure, did so in a negligent manner. The facts were that Mrs. Melchior had given a history to Dr. Catnach that in 1967, when she was aged about 15 years, when she'd undergone a procedure, I think, to remove a cyst, I'm not quite sure, she had, during that procedure, had her right ovary and fallopian tube removed. In fact, that history was not correct when conveyed to Dr. Catnach at the first consultation in 1991. What had actually happened was that her right ovary had been removed and her right fallopian tube had not. Now, Dr. Catnach then carried out the procedure by applying a single Filshie clip to Mrs. Melchior's left fallopian tube, and he didn't examine the right or find the right fallopian tube. He merely proceeded, and the reasons why were not discovered until after a pathology was performed subsequently. But he didn't have a look for it, he didn't find it, so he didn't deal with the right fallopian tube. Mrs. Melchior became pregnant following the consensus of medical opinion that there was a transmigration of an ovum from the left fallopian tube to the right fallopian tube. A viable pregnancy occurred and a healthy child was delivered subsequently. Now, the plaintiffs alleged that in applying the clip to Ms. Melchior's left fallopian tube, Dr. Catnach failed to observe the contrary history provided by Ms. Melchior was in fact wrong. Now, subsequent pathology following a hysterectomy well after the birth of the child concerned revealed that the right fallopian tube had in fact been turned almost 180 degrees back on itself, attached by adhesins to its own supporting structure and displaced towards the uterus from its normal position. So it was a difficult thing to find. And notwithstanding that, the court said that Dr. Catnach really should have made a better attempt to advise Ms. Melchior and Mr. Melchior that there was a risk that notwithstanding he was applying the Filshie clip to one fallopian tube, that there may still be a child born. The courts below, including in the Court of Appeal in Queensland, Dr. Catnach was held to be negligent in the advice he provided to Mrs. Melchior and failing to warn her of the history, that the history provided may be wrong and there was a risk of she might conceive. At special leave, there was just one issue, that is the recoverability of damages for raising and maintaining the child born as a result of Dr. Melchior's negligence. At the time that this matter was determined, damages for costs of raising a child had been rejected in other common law jurisdictions, such as the United Kingdom and Canada, in most of the jurisdictions in the United States, although they hadn't been determined in New Zealand. I should say that in Catnach, the procedure was carried out in a public hospital in Queensland, so the state of Queensland was a defendant and a respondent on the appeal, and at the hearing in the High Court, the states of Western Australia, Queensland and South Australia sought leave to intervene, and they in fact intervened. The case was heard by 7 judges. It was argued by the Melchiors that, inter alia, damages sought were an integral consequence of the tortfeasor's infringement of the very interest of the plaintiff, which the plaintiffs had sought to protect by seeking the tortfeasor's expert services. In other words, they went along to the tortfeasor saying, please help us not have a child and incur the cost of raising a child. And in fact, that very risk they were seeking to guard against came to pass. There was no controversy that the plaintiffs were entitled to other heads of damage such as non-economic loss, out-of-pocket expenses, economic loss and the like. The sole question was answered by the High Court by their majority of 4-3. And for those who are interested, McHugh, Gummo, Kirby and Callan were in the majority, and Gleeson, Hayden and Hayne were in the minority. I've set out here a quote from His Honour Justice Callanan, which I should add too that the paper is being prepared, although for various reasons Ben and I haven't been able to put it together just yet, but it will be available shortly. I think this afternoon was the first time we've been in the same place at the same time for a while. But that quote is quite useful because if I could just take you to it, he says that all of the various touchstones for and none of the relevant disqualifying conditions against an award of damages for economic loss were present here. And he refers to the trial judge and the 2 judges in the Court of Appeal in Queensland were right to identify those touchstones and apply per in our hand to the cases they did. There was no identifiable universal principle of public policy that dictated any different result. And then importantly, he says the damages are not indeterminate. And that's an issue that became highly relevant in considering the question of wrongful life later on. So in this case, the court felt that damages being determinate and an essential part of a duty and breach and the tort of negligence, they could broaden the scope of what was claimable or justiciable. Moving on. Costs recoverable, whether the child was under a disability or not. The child, as I indicated before, was born unaffected by any disability. It was a perfectly healthy boy. And in this case, the court said, as set out there, Justice McKee or Justice Gummo, said that we shouldn't really make a distinction in determining compensatory damages based on whether or not a person is disabled or not. And Justice Kirby said there very succinctly, any denial of the cost of rearing and maintaining a child is the business, if anyone, of Parliament, not of the courts. So he has said, look, if you're not happy with this, don't blame us, the Parliament can deal with it. And in fact, that's what happened, as we all know. The Parliament of New South Wales, at least, did fetter the damages that could be claimed by parties in this state, at least. So too did parliaments in South Australia and in Queensland. But as far as I'm aware, they haven't in the other states. So we arrive at the position at the moment in relation to wrongful birth, as set out there. The compensation for the birth of an unintended child resulting from the negligent conduct of a medical practitioner, parents may claim damages for the cost of raising and maintaining the child. That's the law at the moment, subject to the operation of the Civil Liability Act in South Australia, in Queensland and in New South Wales. Moving on, wrongful life. Notwithstanding comments by His Honour Justice Hayden when he was in the minority in Catanact that to the effect that there was no right in unborn children having a right to recover damages in relation to their wrongful life, there persisted a thought amongst people that the boundaries could be pushed a little bit further. The philosophical dilemma in suing for wrongful life was addressed by His Honour Justice Callanan in Harrington and Stevens. In passing, he said, and he says there, the question that this appeal raises is one that's exercised the minds of philosophers, theologians, scientists, legislators and lawyers throughout the world. And essentially, as he says there, should you be able to claim that but for the negligence, I shouldn't be here? And that's a theme that's repeated throughout the judgments in both Harrington and Waller and James. In both Harrington and Waller, it's important to appreciate that the cases proceeded on agreed facts. There was no trial in either matter. The court determined the claims in answer to agreed questions, and I've set out there the essence of the agreed questions in both matters. There were slight differences, but that's the essence of them, and that is, if the defendant failed to exercise reasonable care in the management of the plaintiff's mother and father, and but for that failure the plaintiff would not have been born, does the plaintiff have a cause of action against the defendants? And then the second question was, if yes, what are the categories of damages available? Now, in both of those cases, His Honour Justice Studdert determined the answer to the first question is no, and so the second question did not arrive. And the Court of Appeal by majority, it was Chief Justice Spiegelman and Justice Ip, with President Mason in the minority, determined that Justice Studdert had actually got the answer right. Now, with those cases, they were both heard by the High Court on the 10th of November 2005 on the same day, and they were both determined also on the same day, the 9th of May 2006. The facts in Harriton and Stevens were that Ms. Harriton had in very early stages of her pregnancy been diagnosed, well, she had a blood test and it revealed a positive result for rubella virus, and the practice she attended was run by Dr. Stevens Senior and Dr. Stevens Junior, and at some point in time she was advised by one or other of them that in fact there was no risks to her pregnancy as a result of the blood test because of the timing involved. Unfortunately, that was wrong information. As a consequence, the child was born with severe disabilities including blindness, deafness, mental retardation and spasticity. It was a bit of a disaster. Now, His Honour Justice Hayne set out there the essence of the plaintiff's claim, and that is that if the plaintiff's mother had been given proper medical advice, her mother would have lawfully terminated the pregnancy. Nothing that the respondent doctor did or failed to do is alleged to have contributed to the appellant developing any of the disabilities from which he suffers. The court took the view that the disabilities from which he suffered were caused by the rubella virus. But it is alleged that had the proper advice been given to the appellant's mother, the appellant would not have been born. The leading judgment was written by Her Honour Justice Crennan, and she has set out an explanation of the wrongful life as distinct from a claim for wrongful birth. And if I might, it's quite a long quote, but if I might take you to perhaps about halfway down, in the Court of Appeal, Spiegelman CJ was of the opinion that it was not possible to avoid or obfuscate the fact that an action by a disabled child, as distinct from an action by the parents, such as a wrongful birth claim, involves an assertion by the child that it would be preferable if she or he had not been born. This raises the difficult question of whether the common law should recognise the right of a fetus to be aborted. And it goes on. The fundamental problem of assessing damages for wrongful life is that the comparison needs to be made to an alternative of no life at all. And this is the thing, or the hurdle upon which the claim's really founded, except for His Honour Justice Kirby. In the Court of Appeal, both His Honour Chief Justice Spiegelman and Justice Ip were of the view that it was impossible to use non-existence as a comparator in assessing damages, and it followed that if damage was not capable of a measure, damage claimed was not actionable. His Honour then went on, that is Chief Justice Spiegelman, averted to some of the difficulty about determining matters such as this. He said the identification of what is regarded as acceptable physical characteristics is a field into which the law should not, at least at this stage of the development, etc., enter. Specifically, the law should be very slow to decide how much disability is to be regarded as acceptable. Is, for example, hereditary deafness enough? There's obviously a rhetorical question asked to elicit the answer no, that would then lead us to think, well, what is? And this is part of the philosophical difficulty that His Honour Justice Callanan averted to in the earlier case of Catanax. Ultimately, the High Court inherited and determined two questions. I noticed the time. The first question was whether a wrongful life action constituted a valid cause of action in tort, and if so, what heads of damage were recoverable. So the High Court made two findings. First of all, it found that Dr. Stevens, who was the obstetrician in Catanax, did not owe the plaintiff a duty of care. In finding that a wrongful life claim was not available, Justice Callanan said that the attempt to compare for the purposes of assessing damages non-existence with the state of existence is impossible. I've put that in because it's a useful summary of the reason why the majority felt that the cause of action couldn't be one that could be sustained. Essentially, they're saying, look, if you can't work out what the damages are, you can't have a cause of action. His Honour Justice Kirby, I should say, felt that the courts dealt with those problems in other claims by manufacturing reasonable person tests and the average person and all the rest of it, and they could overcome it. But for the majority, they thought it was a bridge too far. Her Honour Justice Crennan, who, as I say, wrote the leading judgment, described the assessment of damages as a forensic impossibility and not amenable to being determined by a court by the application of legal method. So that's some fairly clear dicta from the majority about why it is the plaintiffs couldn't succeed. I should say here, or I'll go back before I come to the second finding of the court, I should interpose here that His Honour Justice Kirby noted with a degree of unhappiness the fact that the term wrongful life had been used. It is, in fact, counsel for the plaintiffs in this matter, very learned Mr. Walker of Senior Counsel, has tried to encourage the court away from wrongful life terminology. His Honour Justice Kirby said that you should really be using something else to reflect the fact that, as Justice Kirby saw it, what we were doing was extending the damages range rather than talking about someone preferring not to be born. He was saying, well, what's really happening is they're saying that there was a consequence of the negligence. This is my injury, and he took it to be a continuum of other causes of action, and that the terminology wrongful life just distracted people from really what was being argued about. That's sort of by the by, as it turns out. That is Justice Kirby, held in the end that the plaintiff was in the standard duty relationship between an attending physician and a fetus in utero that we're familiar with in other cases, and that he had found, in fact, for the plaintiffs or the appellants. So the second thing that the High Court determined, again by majority, was that the damage, being an essential part of the tort of negligence, could not be determined. The cause of action was not actionable. And so you can see that although these things were talked about in passing in the earlier case of Catanax, they've had their ultimate conclusion here in Harrington and Stevens. Coming on to Waller and James and Waller and Houlihan, as I said before, this was the second of the two cases heard at the same time and determined at the same time. The reason why there are two cases there is because Dr. James was an obstetrician initially consulted. The other party there is Sydney IVF Pty Limited, and Dr. Houlihan was the obstetrician who specialised in fertility medicine at Sydney IVF clinics. Essentially, the facts are that the plaintiff child was born with severe disability following artificial insemination of her mother using the embryo with a genetic deficiency which had come from the father. He had antithrombin 3, which was a clotting deficiency in his blood, and as a consequence of which the plaintiff, following her discharge from hospital, after being born, suffered a thrombosis, and as a result of that had permanent brain damage, cerebral palsy and uncontrolled seizures. So again, it was quite a disastrous result. The plaintiff in Waller made some other claims in relation to physical injuries postnatally, but the question determined at this time was the same as in Harriton, and they were determined in exactly the same way. I should say here that in this case, because of the circumstances in which baby Waller was conceived, His Honour Chief Justice Spiegelman raised the issue of eugenics. He was troubled by the fact that the case raised an important issue of how public policy should respond to the practicality of eugenics, without taking it much further, but just to raise the issue as a potential problem. The decision obviously was in all fours with Harriton. Again, Her Honour Justice Crennan wrote the leading judgment. The others made some other comments, with Justice Kirby again determining the plaintiff should succeed. The position now is, as Justice Crennan described it very, very succinctly, life with disabilities, like life, is not actionable. And that's probably, if I can give you one takeaway message, the easiest, most succinct determination of what flows from these cases. That is to say, there's not much you can do about it. Before I finish up and pass to Ben, I should say that there are a lot of similarities between Harriton and Waller, and there's two in particular. One is that in neither case was a so-called normal life possible for either of the plaintiff children. And secondly, in neither case, and this is important, could anything have been done to ameliorate the risk of their disabilities occurring or the severity of them, save for performing a termination of pregnancy in Harrington or avoiding conception altogether in Waller. And they're pretty fundamental but for propositions that are being put by a plaintiff. And that's the hurdle upon which they ultimately failed, so far as the majority was concerned. His Honour Justice Kirby would add that both in Harrington and Waller, in showing that their respective damage was a result of the defendant's negligence, the plaintiffs had to establish that the present state of suffering is so profound, enduring and incurable that it is worse than existence. But because of the determinations and the reasons of the majority, the plaintiffs never get to that stage. Finally, before I finish up, I should say that in his dissenting judgment in Waller, His Honour Justice Kirby did acknowledge the point raised by Chief Justice Spiegelman regarding eugenics, and Justice Kirby said that it's an issue about which the common law is now rightly very cautious. That is the basis upon which I now hand over to Ben to tell you what damages might flow.
As Richard has articulated, a claim for wrongful life is not compensable, while the claim for wrongful birth is compensable. The assessment of that claim presents unique challenges. In this talk, I will briefly explore the application of statutory limitation to any assessment of common law damages for wrongful birth claims as found in Part 11 of the Civil Liability Act, issues concerning the proper assessment of a claim for care and treatment provided on a commercial basis, issues concerning the proper assessment of a claim for gratuitous care in a wrongful birth scenario, and the entitlement or otherwise of a claim for loss of earning capacity consequent on raising a child following a wrongful birth. And finally, we'll look at the relevance or otherwise of the NDIS to such a claim. In short, what we will see is that the statutory regime for civil damages in New South Wales and some other states permits damages to be awarded in a wrongful birth claim for the costs of raising a child with a disability, and only in relation to the costs associated with meeting the needs of that disability. In assessing damages for economic loss at common law, the courts have applied the principle that a claimant ought not be entitled to recover damages as compensation for expenditure that a claimant will not incur absent an award for damages. This leads to a controversial divergence in the assessment of damages that may be awarded in wrongful birth claims to the parents of disabled children based on their pre-morbid financial ability to provide commercial care and support. Whilst parents with substantial financial means may be able to establish that they will incur a financial burden in caring for a disabled child and be compensated accordingly, parents of lesser financial means will not be able to establish that they would ever incur those costs absent award of damages and will not be compensated for expenditure they otherwise wouldn't incur. This leads to what many have considered to be an unpalatable result, namely, that the quantum of any award of damages is assessed by reference to the parent's financial means and not the costs of meeting the needs of the disabled child. I'll return to this issue later, but first I'll deal with the claim for non-pecuniary loss. A claim for wrongful birth will usually include a component for pain and suffering of the mother associated with carrying and delivering a child, as well as any potential mental harm consequent on that process. As is well known, Part 2 of the Civil Liability Act serves to modify the common law for personal injury damages in New South Wales, and such damages will be assessed pursuant to the modified common law regime in that Act, and the principles are no doubt well known to all of you in this room. However, a claim for wrongful birth is primarily, at its essence, a claim for economic loss associated with the extra financial burden of raising a disabled child, and not focusing on personal injury. As their honours, as Richard referred to, Justices McHugh, Gummo, Kirby and Kalman found in Katanak, the relevant damage in a wrongful birth claim suffered by the parents was not the unplanned birth of their son, but rather the financial costs of rearing him. Justices McHugh and Gummo stated the relevant damage suffered by the Melchiors is the expenditure that they have incurred or will incur in the future, not the creation or existence of the parent-child relationship. Their honours viewed the economic loss sustained by the parents following wrongful birth was the financial burden or loss incurred in raising that child. Chief Justice Gleeson and Justices Hayne and Hayden, as Richard observed, all dissented, each finding in their own way that the recovery of damages for rearing a child invited a repugnant assessment of damages for the creation of that parent-child relationship. Whilst Justice Hayne held that recovery of damages for the ordinary costs of rearing a child should not be permitted, as it invited an evaluation of the economic costs of raising the child as compared to the advantages or benefits the parents may derive from the child's existence and the relationship between parent and child, he did, however, accept that where a child was abnormal or special needs for expenditure in care or maintenance arose, these extra costs should be claimable. Following Katanak and in direct response to same, Part 11 of the Civil Liability Act was introduced in New South Wales to clarify the extent of any right of recovery for economic loss arising from a wrongful birth claim. Section 70 provides that any claim for damages in civil proceedings for the birth of a child applies to any claim for civil damages for the birth of a child. It does not apply to any claim by a child in civil proceedings sustained by the child for injury sustained prenatally or during birth. Relevantly, Section 71 provides the limitation of the award of damages for the birth of a child. It provides, in proceedings involving a claim for birth of a child to which the part applies, the court cannot award damages for economic loss for A, the costs associated with rearing or maintaining the child that the claimant has incurred or will incur in the future, or B, any loss of earnings by the claimant whilst the claimant rears or maintains the child. And Section 2 provides that Section 1A does not preclude the recovery of any additional costs associated with rearing or maintaining a child who suffers from a disability that arose by reason of that disability. You'll have observed that Part 11 does not seek to limit a claim for non-pecuniary loss, nor does Part 11 seek to interfere with the rights of a child to pursue a claim for personal injury sustained in utero or during the birthing process. However, in relation to a claim brought by a parent for the costs associated with wrongful birth of a child, Part 11 does limit damages that may be awarded to a parent by excluding the costs of rearing or maintaining that child, save for additional costs associated with rearing the child consequent on a disability, and the loss of earnings consequent on rearing that child. Whilst Part 11 modifies the common law by introducing limitations on damages that may be recovered for a wrongful birth, it is important to recognise that it does not provide a statutory entitlement to damages for wrongful birth. Absent a statutory entitlement to damages, the right to damages for the cause of action found in wrongful birth must still be found within the common law. And this brings me to the first item of assessment, namely how to properly assess a claim for care and treatment provided on a commercial basis. The intent of compensatory damages at common law is to place a plaintiff, as far as possible, in the position they would have been had the wrong not occurred. Consistent with saying, damages should be assessed so that they represent no more or less than a plaintiff's actual loss. If a claimant seeks compensation for amounts it expended or will expend in the cost of raising a child, the plaintiff must establish it as a cost that has been met or would be met absent judgment. In relation to past expenses met in fact by a parent of a disabled child, subject to those expenses relating to a need arising from disability and the expenses themselves being proportionate to their potential health benefits, there is no issue that such past expenses are recoverable in a claim for wrongful birth. What is of interest is a claim for future treatment and care expenses arising from a wrongful birth and the juridical basis as to how such an assessment ought to be approached. The decision of His Honour Justice Beach Jones and Neville and Lamb is the most often referenced case on this issue. In that case, Associate Professor Lamb performed an endometrial ablation on Ms. Neville. Ms. Neville alleged that Associate Professor Lamb failed to advise her that she could still conceive after the endometrial ablation. Professor Lamb denied that he failed to give that warning. Ultimately, Ms. Neville later fell pregnant and gave birth to a son with significant disabilities on the 24th of August 2008. His Honour found for Professor Lamb and dismissed the claim. Nevertheless, he turned his mind to what would have constituted an assessment of damages had Ms. Neville been successful. His Honour commenced his assessment by first considering the types of damages that are traditionally awarded in a claim for personal injury. And by reference to CSR and Eddy, His Honour observed that a plaintiff who sues for negligently caused personal injury was traditionally only able to cover three types of loss, being non-pecuniary loss, loss of earning capacity, and actual financial loss. His Honour went on to state that their Honours approved a statement by Chief Justice Dixon in Blundell and Musgrave to the effect that for such amounts to be recovered, they must be amounts that will be paid whether the plaintiff obtained the amount from the defendant as damages or not. The words in bold are of some import. The compensatory principle espoused in Blundell was the effect that before a claimant can recover for future financial loss for expenses not yet paid, he bears the onus of establishing that it is a cost he must and will meet, such that it is not if he is not compensated for same, he will be worse off. This ordinarily involves establishing 1, a legal obligation to pay an expense, and 2, means of making that payment absent an award for damages. Parents in New South Wales are under a legal obligation to meet the expenses associated with caring for their children. In New South Wales, a parent is generally considered to be under a legal responsibility to provide for their children until the age of 18 years. As such, in any claim for wrongful birth, parental claimants may well have an action for recovery for future expenses they will incur pursuant to their legal obligation to provide for their child at least until 18 years of age. However, as noted earlier, the common law has been modified by the Civil Liability Act. Any claim for future expenses of raising a child following wrongful birth is limited by statute to only those additional costs incurred by the parent consequent on disability. But this introduces a conundrum. Whilst all parents of disabled children are obliged to provide for those children, the quality of care they can provide will vary significantly depending on their financial means. Parents with substantial financial means may well be able to establish that they will provide high levels of commercial care, intervention and support and be compensated for same on the basis that by paying for same they will suffer a loss absent an award of damages. Whereas parents with more restricted financial means who rely on public health to care for their disabled child would not be able to establish an entitlement to compensation because they would never have likely incurred those costs. On this issue, His Honour's Justice Beech-Jones observed, this requirement clearly favours a parent of a disabled child who has means compared with the less well off. It is unjust, but is the law as it stands. However, even if a parent has a means to provide extensive care and treatment to a disabled child, an entitlement to future commercial care and treatment is not open-ended. It is generally accepted in law that the period under which a parent is legally responsible to provide for their child generally ceases when that child reaches the age of majority. Whilst a parent may retain a moral obligation to provide for their disabled child into adulthood, that obligation ceases to have the quality of a legal obligation once they become an adult themselves. The weight of authority is the effect that parent claimants are not entitled to damages for the future commercial costs of treatment for caring for the disabled child once that child attains the age of majority, or 18 years. Nevertheless, the position is not settled. As Justice Hislop observed in Waller, the issue appears to be an open one. Any entitlement beyond 18 years will depend on policy considerations. At this stage, the development of the law, if I was awarding damage, I would limit them to the period up to the plaintiff's 18th birthday. There is much commentary to the effect that the age of majority is somewhat arbitrary time to assume an end to any legal obligation on a parent to provide for a child. It is observed that a 16-year-old can cease school, commence an apprenticeship, and in circumstances receive social security entitlements. That child is no longer dependent on their parents at 16 years of age. Likewise, for many parents in our society, providing for children whilst they complete education, including tertiary education, is the cultural norm, and many would view their obligations extend well beyond the age of 18 years. In that regard, it is prudent to observe the dissenting remarks of Chief Justice Gleeson in Catanac, in which he observed, if in principle it is possible to recover such costs by way of damages for negligence in the provision of sterilisation services, then it is not easy to see why the claim should be limited to the first 18 years of the life of the unintended child. It is a feature of affluent societies that children remain financially dependent upon their parents for longer periods. Many children are supported by their parents well beyond the age of 18. The claim in the present case did not cut out at the age when attendance at school was no longer compulsory. In Queensland, that was 15. Why it did not continue into a period of tertiary education is not clear. It was not restricted to items which Mr. and Mrs. Melchior were legally obliged to provide. It included items of reasonable discretionary expenditure. Nevertheless, in assessing such a claim presently under the law as it presently stands, it would not be unreasonable to limit a claim for commercial costs associated with meeting the disability needs of a child until that child reaches 18 years of age, though this should be caveated with the possibility that policy considerations may change, allowing a longer period of care at some time in the future. This brings me to the next area of claim, which is namely for gratuitous care provided to a disabled child following wrongful birth. In Catanac, the majority of the High Court of Australia found on policy grounds there was no entitlement at common law to claim for gratuitous services that may be provided by a parent to a child in the course of a parent-child relationship. Having considered the reasoning of the majority in Catanac, Justice Beech-Jones and Neville observed, such a claim was specifically excluded by Justices Gummer and McHugh in Catanac and not addressed by either Justices Kirby or Calnan. Bearing in mind that the three dissentients in Catanac would not allow recovery of any costs associated with the rearing of a child, it means that the judgments of at least 5 members of the High Court in Catanac preclude recovery for the cost and value of voluntary care provided to a child in such cases. As the law presently stands, there is therefore no entitlement of common law to claim the costs of voluntary services provided to a child, even to a child with a disability. This brings me to a claim for loss associated with reduced earnings as a result of having to divert resources to caring for a child following a wrongful birth. In New South Wales, where a claimant is unable to work as a consequence of the need to spend time raising a disabled child, that does not give rise to a compensable claim. And I showed you earlier section 71(1)(b) of the Civil Liability Act in Part 11, which precludes such a claim. However, that is not the universal position throughout Australia. For example, Justice Elkheim would have allowed same in a wrongful birth claim in the decision of Nouri in the Australian Capital Territory. That case concerned a claim brought by parents of a child born with severe disability in the ACT. The parents in that case maintained that the medical practitioners at the Canberra Hospital failed to provide information as to the likelihood of disability, and had that been disclosed, they would have terminated. In Obiter, Justice Elkheim found that the plaintiffs, if they had been successful, could have recovered future economic loss resulting from an inability to work as a consequence of the need to care for a disabled child, albeit only until the child obtained the age of 18 years. On this issue, His Honour referred to Obiter from Justice Hislop and Waller, and then observed, with some reluctance, I have come to the view that notwithstanding the moral obligation that will continue to motivate the parents after Saba turns 18, they are not entitled to damages after this time. My decision is reinforced by the fact that after Saba reaches 18, there will be a legal obligation on NDIS to support her. I have no doubt this will not be to the same extent as the obviously excellent care she received from her parents. Nevertheless, she will be entitled to support from that scheme. Whilst a claim for loss of income is precluded by statute in New South Wales, this is not the case at common law, and lawyers should be mindful of saying when looking at wrongful birth claims that may be commenced in other jurisdictions. In the section that I showed you from Nouri in the previous paragraph, Justice Elkheim was comforted in limiting any assessment for damages for economic loss, including loss of income, to the age of majority, on the understanding that from that time there was a legal obligation on the National Disability Insurance Scheme to meet the needs of the disabled child. This brings me to the last issue, which is the relevance of the NDIS. The NDIS was established pursuant to the National Disability Insurance Scheme Act 2013. And the objects of the Act include, but are not limited to, supporting the independent social and economic participation of people with disability, providing reasonable and necessary supports to disabled children, including early intervention supports for participants in the scheme, and promoting the provision of high quality and innovative supports that enable people with disability to maximise independent lifestyles and full inclusion in mainstream society. An entitlement to be a participant in the NDIS is associated with disability and does not accrue with the age of majority. An entitlement to join the scheme is not means tested. Noting the objects of the Act, to my mind, it is difficult to see why parents of a disabled child have any legal obligation to provide for the needs of their child consequent on disability at all. As a matter of public policy, society has agreed through this legislation to meet those needs. If parents with means elect to provide alternative supports and interventions for a child with a disability, it is arguable this is in fact an item of discretionary expenditure, not the discharge of some legal obligation to meet the specific needs of the defendant disabled child. If that position were to be accepted, then it is difficult to see why past or future commercial costs associated with the intervention and support of a disabled child could be recovered by a parental claimant, regardless of that parent's financial means. I should note this issue has not yet been explored. One of the issues that also troubles lawyers in relation to past services provided by the NDIS to a disabled child is whether there is a payback to the NDIS. The NDIS is a scheme that provides support and services to a participant. The parents of a disabled child are not participants in the scheme. The NDIS Act provides for a right of recovery from the participant or third-party compensation payers for past services provided to the participant. As a claim for wrongful birth is not a claim by or on behalf of the participant in the scheme, on a superficial reading of the Act, it would not appear that the NDIS would be entitled to recover any sum paid to the parents of a disabled child pursuant to an action for wrongful birth. Perhaps this is logical, noting that any claim for economic loss by claimant parents in an action for wrongful birth would be reduced to the extent that the costs of meeting the needs of the disabled child have been met by someone other than the parents, in this case the NDIA. However, the position is not straightforward. I'm not going to go through in detail, but Section 107 of the Act applies to recovering past NDIS amounts from consent judgments and settlements. It applies if an amount of compensation is fixed under the consent judgment or settlement in respect of a personal injury that has caused to any extent a participant's impairment. Any award of damages pursuant to a wrongful birth action would fix compensation, possibly in respect of the cost of meeting the needs of a disabled child. As such, prima facie, Section 108 may operate to impose on a third-party compensation payer a debt payable to the NDIA for services provided by it. Even on balance, when advising on a wrongful birth claim, consideration should be given by a potential compensation payer to notifying the NDIA of the claim, as the NDIA may well form the view, perhaps wrongly, it is entitled to pursue an amount payable by that compensation payer under a judgment to the participant as a debt to it, and that issue should then be clarified before any payment is made to the claimant parents by way of settlement or judgment. This leads to, I did not put that. A word of caution.
Word of good. Whoa.
It's not nearly as dramatic. The paper, which is very advanced, but not yet proofread, leans heavily on the obiter in Neville and Lamb in circumstances where an appellant court has not yet had to consider the proper measure of damages for wrongful birth. Whilst it is considered that the reasoning as expressed by Justice Speech-Jones in Neville reflects the current law, that reasoning relies heavily on principles drawn from authorities that were otherwise not concerned with a wrongful birth claim. There is significant scope for an appellant court to distinguish those authorities in order to avoid what it may well perceive to be an unjust result, namely applying the compensatory principle found in Blundell and Musgrave to limit the assessment of parental gain for wrongful birth based on the limited financial means of the claimant as opposed to the needs of the disabled child. Whilst the paper does not seek to explore how those authorities may be distinguished, that itself would be a paper within itself, it is safe to say that there is no certainty that another first instance court or an appellant court would follow the approach to assessing damages in a wrongful life claim consistent with that approach in Neville, and therefore that should give some caution to the manner in which one advises clients on this issue. And that's the end, and we made it with 8 minutes to spare. Thank you.
So the job of the chairperson is to keep the speakers to their allotted time, and I think we're getting great. I've done a superb job. The other job is to moderate questions. I don't know whether we've had any beamed across the internet. Good.
NDIS. So NDIS, my understanding is that, my experience is that if the plaintiff had NDIS payments, then there's a payback. But then they can keep getting NDIS in the future. So it's not like workers' comp where, you get the payback, that's it. Workers' comp cuts out. So, and I don't know if there's any authority on this as to whether you factor in the fact that they're just going to keep getting NDIS in terms of future damages, double dipping and all that sort of stuff. Is there any comments on that? Or?
Yeah, I think it is. That was the argument that I was referring to, because the juridical basis for the assumption that the parents or the parental claimants have an entitlement to economic loss is on the assumption in Blundell and Musgrave that they have a legal obligation to make those payments. But arguably, as a matter of policy, there is no legal obligation to make those payments to care for the child, because we as society, through that piece of legislation, will be providing for it. So if it was ever tested, it could be arguable that that is discretionary spending. That is, the parents have chosen to incur a different regime, more expensive or alternative regime, for the provision of support services to their child, as opposed to a legal obligation to provide those particular services. Now, that's a thought I have. It has never been tested.
Because I do have a matter where there is a somewhat large differential between a co-defendant's reserve and our reserve. And so they're saying, well, NDIS, so, it's ours is going to be tiny. So it's like, okay, it's fine. But, I just want to sort of, find out if it's never been tested.
Is that?
No,
it hasn't.
No.
And that wasn't a wrongful birth claim, is it?
Sorry?
Is that a wrongful birth claim? No.
Yes.
It is?
Yes.
NDIS precludes in the future, though.
It concludes in the future.
It can preclude in the same way Centrelink does. It's that there's a
A
formula.
preclusion period, or
There's a
preclusion,
formula.
100% preclusion, or
No,
there's a
well, the formula
preclusion period.
it reduces according to how much you have in assets, or what you, yeah.
Oh, that makes it completely uncertain then how
It
you,
does,
how you deal with it.
except that I suppose wrongful birth is different to every other type
Yeah.
of claim because the participant isn't, it's not the participant that's holding the assets.
Okay, okay, so food for thought.
How do you deal, and this is not a wrongful birth one, but in a normal NDIS, you know, just a straight out negligence kind of claim, and someone has the ability to go to NDIS, as you pointed out, it's not asset tested. So there are circumstances where plaintiffs kind of say, well, we're not going to NDIS. They claim their care and then may go to it in the future and it's not asset tested. So there's the double dipping, but obviously that's post settlement. How do you?
You have to have, just because this is a talk on wrongful life, and so, wrongful birth, sorry, and so that is talking about an economic loss claim brought by parents, as opposed to a claim for damages arising from the needs of the injured person itself.
Yeah.
And so they're very different paradigms. And I know there's often complaining about the risk of double dipping with NDIS, but what you are compensating in a personal injury claim for that person is their need for future services arising from the negligent act of a defendant, which is very different to the economic loss that may be sustained by the parents of that disabled person. It's a different kind of approach.
No, I appreciate the difference. I was just wondering if anyone had any
But
ideas how to fix that.
if that were to change that position, the Blundell position that's then in come down in the OBITA discussion, and the ability of a parent to what they could pay in the future is displaced as the relevant position, then doesn't the age 18 aspect sort of fall away too, because NDIS isn't it doesn't, sorry, I'm not expressing this very well, but
No, logically you'd think it would for the same reasons, but I suppose that it's hard to know what the court might do.
yeah.
But yeah, logically, if you apply the same rationale and the same reasoning, it should fall away as well.
Yeah.
But it may not.
Just
It's
in terms
just-
of how we assess our damages,
exactly.
in terms of the risk, it's not just looking at.
As you know, Lucy, it's very unsatisfactory where we are at the moment.
But as we look at this room, it's largely defendant lawyers, and as it presently sits, the law favours the defendant's assessment over what plaintiffs bring. But the question is whether that's right or fair, and that's the difficult conundrum that all lawyers need to come up with.
I would just add to what Ben said. I think it's right at the moment. I mean, the law does favour defendants, but defendants have to be very careful about how bold they want to be in prosecuting the presently understood position, because sooner or later we're going to come across, or defendants will come across a plaintiff who is feeling quite good about things and wants to take it to be determined somewhere, and there's a very real risk, bearing in mind everything that Ben said about the law as it is at the moment and why we've arrived at it, but there is a very real risk that a court may, for whatever reason, start going in the other direction, and then it falls on that defendant to tell every other defendant why it is they decided to run that hole and establish without any doubt that the damages are actually a lot bigger than they might otherwise be.
Questions from outside the room?
They should be able to ask a question.
Oh, right.
Stacey King.
A wrongful life claim where the plaintiff actually wrote to NDIS seeking as to whether or not there would be a payback and
We want to know the answer.
Technicians. Could you repeat? Can you repeat the question? Is that coming in by
I've
YouTube?
just sent her a message and let her know we're having a connection issue with her, just to get her to send us the question in the text box.
Was there another question?
We do have another question through here. So this one is for Ben. Karen has asked, do you have a view on the recent decision by Levy DCJ in Dupar regarding the economic loss award to the mother, characterised as being while she could not work because of her own psych injury rather than that loss being sustained during when the child was raised?
Thank you, Karen, for the question. I don't have a view on that as such because I'm not familiar with it. I don't know Judge Levy's decision. Do you know?
No.
Can you repeat what Judge Levy said?
Characterised as being whilst she could not work because of her own psych injury rather than that loss being sustained during when the child was being raised.
Well, that would be it depends a bit on whether it's what other claims were made at the same time and who was making them, so it's a bit hard to comment. Not avoiding the question, and perhaps if we get the citation of the case, we could work it into our paper. That might be the best way of addressing that issue, simply because I think we need to have a better understanding of the claims that were made and by whom, and the evidence that Judge Levy relied on to make a finding in relation to that particular plaintiff about the reasons why she was suffering an economic loss. Not much of an answer.
Was the party named Patrick? Did you say Patrice?
Dupar.
Oh, Dupar.
Karen has responded, she said sorry about that.
It's okay. I need to apologise.
And have we had any joy with the other question?
No, we haven't heard back. We haven't heard back from Stacey.
That's a shame because I think we'd like to know what the NDIS or NDIA had to say about that.
She's raised her hand again. Stacey's back online.
Can you repeat that?
Can you hear me now?
Yeah, yes, we can.
Okay, fantastic. Sorry, I was on my headset, so I think that may have been the problem. I apologise. I can confirm that in my wrongful birth claim, NDIS have confirmed that there will not be any payback, nor will there be any preclusion period.
And that makes sense. That does make sense because it's a claim for the economic loss of the parents. And if that cost has been met by somebody else, then there shouldn't be any payback. So as a matter of logic, that seems sensible, but the NDIA isn't always initially logical.
And that was the exact reason that NDIS provided. So it seems that they've been sensible, at least, with this issue.
And that should embolden people to then approach the NDIS to get that letter to give everyone comfort. Because it's better to have everyone knowing that position when you go into settlement or to hearing than having it unclear. But thank you, that's good to know that they're doing that.
And one can imagine that the NDIA has sought legal advice from people in the authority and also the Attorney General's Department about what their obligations may be and what their rights are as well in relation to participants and parents who are not participants. So hopefully that's a letter which is going to be republished in other matters.
Obviously, the issue then becomes, well, what will their future NDIS entitlements be? Because that's definitely an unknown when you're discussing a child, but that's another issue.
That's good to know.
Thank you.
Thank you.
All right. Now, talking of it, my daughter arrived and went downstairs about half an hour ago. So
We'll call it a night.
call it a night.
Thank you, everyone.
Thank you.
Okay, thank you.